Good morning, ladies and gentlemen, and welcome to another episode of PLA with myself, Nick and Bruno. The first question goes out to you today, Nick, and it reads as follows. There's a prospective tenant that has paid a deposit, Nick. The necessary checks have been done. The tenant had some maintenance request, which the owner agreed to and started with over the weekend. It's been a to and from with the tenant and the lease agreement in the last 2 weeks. The tenant requested many of the clauses in the lease to be removed. After clauses were explained to this tenant and referenced to in the Rental Housing Act and the CPA, the tenant still tried to basically bypass these clauses and tried removing them from the lease. We, as obviously the agents, advised the landlord that against most of this, as the clauses in that the tenant tried to remove was to actually protect the landlord. For instance, if visitors stays too long, they could charge a fee, etc. The prospective tenant sent back the lease, signed the lease agreement on Tuesday evening with many of the clauses scratched out, only to let us know the next morning that lawyers in his family feel that the lease is too complex and doesn't protect him as the tenant. Basically, the question is that the tenant actually withdrew the lease then, Nick. Now, the question is, the scenario is that they don't have a signed lease by both the tenant and the landlord, right? The tenant has obviously withdrawn the lease now, but the landlord had then actually made specific changes to the property, and that incurred expenses upon the request of that tenant, such as the fences, etc. Now, the question then, can the landlord claim a penalty of some sort from that prospective tenant? She had quite a substantial amount that she put into obviously bring up the property into the standard that prospective tenant actually did put forth. So yeah, I hope it makes sense. But long story short, get the lease. They say they change the lease, but pay the deposit, but say extend the wall or whatever, or give me extra working space. Then the landlord does all of this using their own money, and then they basically pull out of the lease, and there you have it.
Yeah. So let's start with some basic contract stuff, because what they say in the question is, well, we don't have a lease agreement that's signed by both parties. And we must reiterate that in our law, a signed lease agreement is not necessary for a lease agreement to be in place. Okay, you don't have to have a signed document. You can have what is a verbal or a tacit lease agreement that comes into place between parties. Okay, and a contract can be concluded without signing a written document. However, in order to establish that an agreement of some kind, be it a lease agreement or anything else, has come into effect, we have to have what we call in the legal sphere the meeting of the minds. So you have to have two people who are pretty much in agreement on what are the terms of a particular agreement, what are we agreeing to. And once you've got to that point, you can say that an agreement has come into place between the parties. Okay? It doesn't matter whether it's sitting in writing or not. Now, the difficulty that I see with this question is, can you establish at what point there was a meeting of the mind between the landlord and the tenant so as to show that there is a lease agreement in place? There's clearly something, because the tenant wouldn't have paid a deposit over to the landlord if there wasn't some sort of intention to lease. Okay, that is a point which you could say, well, there's a lease agreement because the deposit was paid. I gave her, my banking details. She paid it. But then there are also difficulties with regards to the clauses. So that, as far as I can see from this question, the tenant has been disputing clauses throughout, and has been, when she sent back the signed lease agreement, she struck out certain clauses. Now, in our law, if you send a lease agreement to someone with particular clauses that you want, and they send it back to you where they've now struck out particular clauses that they don't want, that is technically a counter offer. Okay. In our law, you need certainty. Okay. There needs to be a certainty as to what terms you are agreeing on. And if someone strikes out clauses, it is deemed to be a counter offer. And we've dealt with this extensively. I've had high court applications where there have been arguments where, well, I was still intending to, enter into the agreement. However, I just decided these clauses were irrelevant or didn't matter or whatever the case is. And you can't approach negotiation in that way. As a standard, you should appreciate that any clause which is included in the lease agreement when the landlord transmits it to the tenant is material to the landlord. It's not for the tenant to, dictate what's material or not. So it seems to me that this is going to be a counteroffer by the tenant to the landlord. Okay, that feels like what it is. We don't have the benefit of knowing exactly what they struck out, but they look like material clauses to the landlord because, as the writer says, there are protections in the place of the landlord, and so they should be deemed to be material to them. The problem now is, on the facts that I read now, it seems to me that there wasn't a meeting of the minds. Okay, it doesn't seem like the parties had agreed exactly what the relationship between them was going to be, regardless of the fact that the deposit had already been paid. Okay, that's one aspect of the agreement, but you need to have all aspects of the agreement materially down. And so in that circumstance, what I think the landlord's done in this circumstance is made a mistake. They have gone and they've changed the premises and done a whole bunch of things, to try and get the tenant into occupation of the premises without actually nailing down the agreement between the parties as it is. And that is a mistake. The agreement should be in place, and part of that agreement, you should have agreed to, okay, well, these are the things I'm going to do to try and get it to a standard that you want. Doing the things first and then trying to knock the agreement in, unfortunately, leaves you in a situation like this where you expend a bunch of capital to try and make sure that the lease comes into place. And now they've basically withdrawn. They're showing an intention that they don't want to enter into the lease agreement. And I can't see on the facts that there was a time at any point in the negotiation where a lease could have been formed. Okay, I might be wrong on that. This is something that you do need to go see an attorney so that they can look over the actual details of the case and they'll properly advise you. And the last thing I'll add on to this is, obviously, there is still, even though the question of whether there's a lease or not, I think there's some difficulty there. That doesn't necessarily mean that the landlord is on the cold. Okay, the landlord has done some renovations to the premises. The reason that they did these renovations were representations that were made to them by the particular potential tenants in the circumstances, and they are now out of pocket because the tenants has decided, actually, I'm out. So there is a prospective damages claim, okay, that the landlord can potentially claim for the renovations that have been done on the basis that there was a representation by the tenant. The landlord relied on that representation, and now they've suffered damages as a result of that. So there is a potential for a damages claim. I don't know, based on what I'm reading, whether there is a potential to keep the lease agreements in place. But what is very important, and Bruno, we've talked about this before, every case depends on the particular facts of that case. What the communications between the people were, what are the clauses that were in the lease agreement, what did they strike? All of this, unfortunately, requires a keener eye to look into the facts. So, to the writer, I wouldn't. It's not hopeless. There's definitely options available to you, but you do need a legal expert to go look and see what your next step is in the circumstances. I'm afraid that's the best advice I can give at this point.
Absolutely.
Yeah. Okay, so thank you very much, then Nick, and then